Any mention?
May I please, Your Lordship? I beg to mention item number 3.
Item number 3 of the hearing list, yes.
Yes, sir.
Yes.
I ask for 2 weeks' time, my lord. I ask for 2 weeks' time.
Why? This is
Because-
2016 matter.
Yes, Your Honor. Yes, my lord. For the reconstruction of file, Your Honor.
For the reconstruction of the file. File was gutted there.
Yes.
Okay. What is the matter about, Mr.
Regarding, they are asking land compensation for construction of the road.
Okay. 2 weeks.
Yes, sir. Yes, my lord.
Ms. So-and-so, London Council appearing for the petitioner. Praise for grant of adjournment in the matter. The prayer has not been opposed by Mr. Hajarika, Learned GA. Accordingly, release this matter after 2 weeks.
May we please, Your Lordship? Your Lordship, I beg to make a mention for item number 13, Your Lordship, as I need some more time to research. Lordship, if the matter
Who's the
can...
other side?
Sir Gurung, Your Lordship.
Lordship, no objection.
Yes, 13 you just said.
3 weeks time, Your Lordship.
3 weeks, why 3 weeks?
Lordship, I still need to do some more research, Your Lordship.
List after 3 weeks, just preferred by the London Council for the petitioner.
Highly obliged, Your Lordship.
Please, Your Lordship, I beg to mention item number 12, Your Lordship.
Yes.
If the matter may come up after 2 weeks.
We have no objection, Lordship.
Okay. This also after 2 weeks on the prayer made on behalf of the appellant. List after 2 weeks on the prayer.
Much obliged.
Obliged, my lord.
Your Lordship, I beg to mention item 5 and 6, Your Lordship.
Yes, what happened?
Your Lordship, in item 5, we have to file our rejoinder. I'm praying for a week's time, Your Lordship, since the petitioner is from Garo Hills. He had some difficulty to come.
These are connected 5 and 6.
Your Lordship, it's connected.
You are appealing for the petitioner of both the cases.
Both the cases.
And who are the respondents?
Respondent, GHTC and
For respondent 1 to 3, Your Lordship.
1 to 6.
Okay. On the request. Any objection? Wait, what?
No objection.
Any request made on behalf of the petitioner? This is matter after 1. This 5 and 6 releasing order.
Highly obliged.
Yes.
Please, Your Lordship, I beg to mention item number 7, Lordship.
Yes.
7, 8, and 10 are connected, Lordship. If one is adjourned and 7, 8 or 10 are also adjourned.
They are represented by the same council.
Item number 10, the petitioner.
The other petitioner, Lordship, in item number 10.
These are all service matters.
My lord, yes. Termination of the teacher.
Just like
Yeah.
For how long? For how long you want?
Just 2 weeks, Lordship.
any objection by anyone? No.
No, Lordship.
Okay, 7, 8, 9. Then,
Continuously.
Madam,
7, 8, 10.
7, 8, 10, Lordship.
10, I am there.
this
for
also?
private response.
Just say on the prayer made on behalf of the petitioner. This is matter after 2 weeks. Yes.
Much obliged, Lordship.
I beg to mention item number 11, my lord. In this matter, my lord has directed us to file an impediment impeding the managing committee of the school, my lord. So I am filing it today, my lord. So let it come up next week, my lord.
This is also a service matter.
My lord.
You are supposed to file what?
An impediment application for impeding the managing committee, my lord.
There's an order by the school
My
to
lord, my
impede.
lord. On the last date, my lord has directed us to file an impediment application.
Yes, Mr. Abraham.
It's no objection.
Is this correct that they will have to?
Yes, there was an order to implement this managing committee as a party.
At whose instance? Court wants it or the party?
The party insisted the court has passed an order accordingly, yes, Your Lordship.
Okay. Landed counsel for the petitioner submits that some more time may be given to the petitioner to file an application for improvement of
The managing committee of the SSA, Pushkanipara SSA school, madam.
the managing committee of such and such school. You have to get the names color in the orders. The Mr. H. Abraham, London GA has no objection. Prayer allowed. List after 2
Next week, madam.
next week. List after 1 week.
Madam.
List after 1 week. Yes.
I'll place them.
Item number 1.
Yes. What is this, madam?
My lord, this is an application which is filed by the petitioner, my lord, for a grant of parole, my lord. And the application has been addressed to the superintendent of jailer, and the superintendent of jailer has not decided my application, whether I'm entitled for parole or not, my lord. That is.
Any instruction?
May it please your lordship. Lordship, I just received a file. Let me go through, then I'll inform.
You have a scheme.
I don't think we have a parole policy. I don't think. Let me have instruction, your lordship, a proper instruction in the matter.
Let him file these things. You will file an affidavit. You file an
Your
affidavit.
lordship, yes.
Okay. Mr. Andy Shulai.
And another point, another fact also, your lordship, there is also a sumo to read before the Honorable Supreme Court. It appears, your lordship, from the affidavit filed by the state that his name also has been found mentioned in that affidavit.
Yes, there was a.
Yes, your lordship. That is
See, like.
that is a sumo to read criminal number 4 of 2021. It's still pending, your lordship.
My lord,
There's a matter, of course, pending in appeals court.
Yes, my lord. But my lord, my only grievance is that, my lord, I have filed an application before the superintendent jailer, my lord, and the IG prison, deciding my parole application. If I'm not entitled, my lord, they have to reply. My lord, that is my only grievance here.
You want to say that once you file a representation, they will have to respond to it, isn't it?
Yes, yes, my lord. They have to respond to me, my lord.
Okay. Mr. Andy Shulai, learned AG, appearing for the state. Prays for grant of some time for enabling the state to file an affidavit in opposition in the matter. Clear, allowed?
Let it be 3 weeks, your lordship. Let it be 3 weeks.
3 weeks.
Yes, my
Lordship.
List for 3 weeks.
Highly obliged, my lord.
Hearing item number 4.
Yes,
Your Lordship, I pray this matter may be taken up at the end of the board, Your Lordship.
at the end of the board. Okay, what is the matter, Mr. Jha?
This is with regards to the grant of ACP and MSCP, my lord. Assured career promotion and
There is, okay.
modified assured career promotion, my lord.
There is otherwise no promotional avenues for this.
Otherwise, there is no. They say that the only the the earlier fixation, the initial fixation, my lord, is they are treating a merger as a or a upgradation as a promotion, my lord. Then the entire issues has come up.
You are ready to do it today?
My lord, even my lord can come next week if it is.
Because we also have some difficulty with our peers and they're both on leave.
My lord.
So Mr. Lindeming is helping us today. Just on the request of the petitioner, list after a week. Next week is all right for you?
Yes, Lordship. Much obliged.
Item number 9.
Yes.
Lordship, this is with regards to Akung, Lordship, Dokmasip. So, Lordship, it will take at least some time, Lordship. Thank you.
I think your lordship, it can be sum up, very brief. Means what happened, earlier litigation, the EM inchers gave an order in my favor. Then I have challenged an appeal. So when they have challenged an appeal, then it has gone in their favor. Then it came to High Court. When it came to High Court set aside both the orders. Remanded back. Then again they came to the High Court for one order, small order. So Justice Azhasan again remanded back. Then this is the third time they have come, your lordship. What happened? EM inchers decided in my favor, and CM also decided uphill that same order. This is a concurrent finding, and in fact, district council record also supports us. The affidavit also support us. So due to concurrent finding, I see that there is not much to go into that.
Is it with regard to the Nokmaship?
Nokma no, Aking. Aking means there is a village within our Aking. They say no, that is their aking. But
They say that is a separate.
separate aking.
So there is margin against merger of aking.
No,
Or
yes,
amalgamation.
no, they are within our aking.
Okay.
There's a village within our aking.
So their grievance is against the merger of their aking under you.
With us.
Lordship, yes.
That is the issue.
No, the district council they held, Yeminchas, they held that our aking is there, they don't have aking. There is a village. That's the only condition.
But that is all right. But then their grievance, we are not going to merit.
Yes.
See, like right now.
So this
just
is
for the factual aspect is that they are opposing the merger of their aking under you. They say they have a separate entity.
separate aking.
That is what the case.
That is only the point.
Now, if that is the main grievance, how this court will decide that?
No. Therefore, the concurrent finding already has been there.
Definitely.
That being the region, so there is
situation
no
is there.
case, no case lies.
Mr.
And what
Sharma-
happened? Your lordship can see a moment. Your lordship can see the prayer portion. Just the prayer portion. If I come, means I want to brief the whole matter. At page 27, your lordship will see.
Yes.
Page 27.
Yes.
From the bottom, your lordship will see. 1, 2, 3, 4, 5th, and be pleased to uphold the final judgment ordered 15/3/2013 passed by JSC Revenue in the appeal 15/3/2013 asked to uphold by this honorable court, your lordship. So the order 15/3/2013 has been already decided by the honorable High Court, your lordship, at page 130. If your lordship please to come by page 130. WPCA 79, that SH 130, and the relevant page 131.
130.
131, your lordship, relevant page.
Yes.
Para 5, your lordship. Para 5.
Accordingly, both the orders so and so and so and so set aside.
Set aside. He wanted set aside by this High Court order to uphill here. So that is what I'm surprised, your lordship.
Can you review order passed in a writ petition in excess of jurisdiction in another writ petition?
Lordship.
Which was
That prayer we are not insisting, but as of the matter of the impugned order, the main challenge of that order is 2017 and 2018, because the crack of the case here, lordship, in the RCC don't record. The Majumdar has first, he has, on the basis of the direction from the EM, they have gone for an inquiry, spot inquiry. During the spot inquiry, what have happened, lordship? There was a violence. This the private respondent and their people, their clans, have forced and there are some things that it is recorded even in the Majumdar report, even in the order by the EM. They say that they have forced the Majumdar to sign in the map and the boundary prepared by them. It is on record.
These are all factual aspects.
Do
you expect this court to appreciate all those things?
Lordship, I'm just saying.
See,
because
we are in a judicial review. You understand that very well. Our scope is very limited. So until and unless there is a procedural absence or something perverse, we will not interfere.
But
even if you have a good case on merits, it's not like an appellate court where we will go and appreciate all the factual aspects.
But here, lordship, yes, lordship, I admit, but only one thing is, even the EM and the CM have never followed the guideline, the principle,
yes,
while trying the cases.
What are the principles?
Those
and what are
actually,
those
lordship
guidelines?
is very much aware in that one particular judgment is in the Dorisha. Even my senior
Framing of issues.
Yes, framing of issues, leading evidence, and recording of the examination of the document. All those things were neither in the other first by the EM. It should have been done in the court of EM. Nothing was done.
So
and
then we have to set aside the order. We have to remand it back again.
Lordship, because
if issues are not at all framed, isn't it?
yes, that is the admitted fact, your lordship. If we, in every order of the EM, because EM is the meant the court which supposed to take the evidence and also supposed to take the documents to examine, exhibit it, and also framing of issues. None of the EM on the
Are you equating EM court with the civil court?
lordship.
Are you equating EM with the civil court?
It's because
See, the taking of evidence by EM court, in which manner it should be taken or what not, it will be up to EM. Is there any let down procedure that
yes,
witnesses to come, is to be deposed?
it is there, Lordship, because there is a judgment, because that judgment is has been being relied.
The Dorosing case,
If
1988.
yes, Durasamy is okay, but then he is saying something else about Durasamy speaks about
Yes.
framing of issues and reply. That is we can understand. But then he is saying,
my lord, if I just read out, Para 20, for all this reason, we hold,
I have this
all the
point.
revenue members alone have jurisdiction to decide the type of dispute at hand. But then, while doing so, the revenue member has to follow the fundamental principle of judicial pronounce. This being the framing of issues which has been regarding as necessary for the court to get the grip of the case. Opportunity to let evidence on the issue frame. The evidence given could be recorded in full or summary of the same could be noted. So, my lord, it is not that we have to do it as per the civil code what they are doing.
see, quasi-judicial body and a judicial body are two different things. Now you have to understand the decision of this. Okay, when it speaks about recording of evidence, it may not be in the matter. Then would you like to say this evidence act will be applicable? If you equate the court of EM with a civil court, and if you say that he has to discharge a similar function, that means you have to make this evidence act applicable to that. It means then the witnesses will have to be administered oath.
Yes.
And then they will be examined like these things. Is it the procedure?
Yes, Lordship.
So EM is a civil court.
EM is actually not civil court, but they said there is a one in the Administration of Justice Act. It says that though it is not the civil court, but you have to follow the spirit, not in it. That was there.
That is in different context. You are talking about courts under district council.
But Lordship, even if that is not following the exact CPC also, there is a certain guideline has been provided where they are supposed to follow. That was not there, Lordship.
What are the guidelines?
Guideline, as I have stated, that leading of issues, framing of issue, the issue also has to be discussed, at least whether
So no issues have been
nothing has been
Yes,
done.
no issue has been framed in this
No,
matter.
Lordship.
So then
Not even single. There are various order has been passed by the EM. There is not even one EM who has passed, who has framed the issues.
So that is your only case, is it?
Yes, Lordship.
This what you have given is not legible, not very legible.
Yes,
See?
Lordship, because I'm sorry, because I just get it. But the one very better thing which I like to rely with this one is annexure 8, Lordship, where that is the fact of that's a crack of the case, where how the case started and how it begins, Lordship. This is very interesting, Lordship, which I like to draw Lordship attention, Lordship. The page 53 of my readings, which why I like to rely is this is very important, which I feel, because this is the order of the EM. Here the petitioner is saying that the case of the adjugator Achung was in existence, and they also admitted it was recognized by the earlier by the deputy commissioner, the then deputy commissioner W. So since
It's a boundary dispute. Is it a boundary dispute?
Yes. Now here in this.
No, this order, annexure
Yes.
8, page
Yes.
53, it says that
Yes.
nature of the case boundary dispute between Magupara and Adugachal
Akung. Yes,
So
Lordship.
is it a boundary dispute?
This order has been set aside by the judgment. I refer to your lordship, TNK.
No, that is okay. We are not speaking about the order, but then on the heading, before the order is passed, if you can kindly see that
Yes.
page 53, the subject has been mentioned as this way.
Yes. Nature of the case, boundary dispute between.
And then below that there is order.
Yes.
It is not the part of order.
Now, what happened here is this order was passed without
You are Adugachal.
Lordship. They are the private respondent are there for Magupara. This yes, Magupara.
Now your map was approved by this.
Yes, on this order was passed. On what basis the order has been passed, we don't know, because there is no application by the parties. There is no spot inquiry. Neither I was given an opportunity to show cause. This is the order just passed and cancelling by Akung entire
No,
Akung.
but then see, he's in charge of London Revenue, isn't it?
Yes.
He has some executive function. You just cannot say. See, any officers under Deputy Commissioner's attachment that they will do their administrative work only on the basis of a petition.
No,
This is not a judicial order.
this is not a judicial order, of course, Lordship. But while passing this order, they should issue notice to us, at least to get the clear inform how this order can just pass in this way, Your Lordship, and who has filed any application, and on what basis this order, whether there is any report from the Majundar, that also was not there.
Now, where is the creation of Advocature Locking? This is cancellation of Advocature Locking.
This is the cancellation of the Advocature.
Your existence, how do you prove it?
Yes, my existence, my lord. It is
Something prior to it?
It's 47 also, that page 47. Page 47, that is Annexure 6, my lord.
Yes, what is that? It is 1988. Order
Yes.
1988.
It says that the clan people numbering so and so Advocature Akung appear before me in my office chamber, heard statement of the Mahari people and found unanimously agreed registration in favor of Sri Henry Sangma and his wife Felony here petitioner Marak. Beside, I have consulted the Akung record and the statement of Maharis are true. I therefore declare and appoint Sri Henry Sangma and his wife Srimati Felony Marak as the Nokma of Advocature Akung number 215 with effect from today, 29 April 1988.
This is a judicial order or executive order?
Is the order passed by the
like what you said about the earlier order, which went out, that no notice was issued to you, not this thing. So this is a similar thing. No notice was issued to them. They are also not present. The same contention will apply here also, isn't it?
That's why I said, Lordship. But there was.
You are not replying. You reply. You jump to some other thing. You avoid this court's question.
Lordship.
When you referred to page 53, Annexure 8, you said this order was passed behind your back.
See, Lordship, in this order, may I humbly submit, in this order, this is only an appointment recognizing and approving that Advocature, Advocature was in existence, so I am appointed as Nokma. But there in the otherwise, there they have cancelled my account. Cancellation and appointment of Nokma, Lordship.
Your appointment is done without giving notice to anybody.
Because
do you say only in 1988 you have been your Aking was created?
Lordship, here they have.
Is it the first order that by which this Aking was created?
No, before that also, prior to that also, our Aking was in that map, Lordship. I will come to the text. There is a map, Lordship.
It means one officer came
page
and
37 is there, Lordship. Page 37.
You granted the status of one Aking. Then another man came. He is not doesn't like Mr. Dey doesn't like you. He consulted.
No, Lordship.
If you get something wrongly, then it goes also away that way, isn't it?
Our map also was approved, my lord. But here our case is because there was Akung, Advocature Akung was there, and we have been appointed at Nokma, and
is it just show us what is the evidence of existence of Advocature Aking prior to this 29 foot 1988 order?
There is a map, my lord.
See, you have been appointed Nokma. This 29 foot 1988. It is only appointment of Nokma, isn't it? It is not a creation of any Aking. It says, the first line says, the clan people numbering 16 of Adugacho locking appear before me. Now, where is that Adugacho thing? Just because 14-15% they go and they say that we are belong to some Aking, will it mean that will be that will create a fresh Aking?
No, that Akung was there, Lordship.
How do you say, on what basis?
There is the page.
Now, Aking, normally Aking has its own existence, or it is basically, you see, if at all, definitely Aking has customary existence, there is no dispute about it. But then whether those all Akings are registered with the district council, Mr. Dev,
Yes.
so if there is any Aking in existence, that will be reflected in your record, isn't it? So that is where.
And that has been done by the then Deputy Commissioner in 80s.
Yes. That Akung number is that this particular Akung has been registered. That Akung number is there, Lordship. Number is there, Lordship. Akung number is there.
2 of 15.
Yes.
Isn't it?
If I can just pause my friend for 2 minutes, maybe, if I can be permitted to submit two things that what my friend is hitting around. He's hitting around the bush that the evidence was not laid down, issues was not laid. That is why he is aggrieved and before this honorable court. Now, my lord, come to the order dated 28/12/2017. His case is demolished, my lord, by this order.
What is that order?
This order will be on page 151, my lord.
Probably this matter was heard.
Yes, it was heard, my lord. Now, because of the pagination only, my friend has.
You are referring to what page? 151.
151. The order of the CEM.
Yes, this is handwritten copy, Mr.
No, my lord, it is a type.
Okay, yes. 28/12, yes.
Yes. Heard both sides in details, referring the direction issued by the Honorable Meghalaya High Court on 27 July 2013 in writ petition number 7, whereby to the executive member in charge, Land and Revenue, Tura, directing to decide the respective claim of the parties afresh after giving full opportunity for putting up their respective case. Accordingly, thereby the court has framed issues. First thing, my lord. Second thing, examine the witness of both the parties.
Yes.
And heard the parties as directed by my predecessor. So, if that was the case, only what my learned friend is projecting, my lord, then by this order itself, my lord, is demolished. He has to go beyond this, my lord, to show that why this order is wrong.
So,
And
issues were framed. That is what has
Lordship, they have reflected in the order issue has been framed. Where is the issue? How it is discussed? Because this is just a summary. We can say that frame has been issued. Where is the statement recorded by the court? They have clearly admitted that the witness has been examined. Then practically, Lordship is very much aware that when examination of witness is examined,
your contention is that these are not factually correct.
Lordship.
Isn't it?
Yes.
So we'll call for the record and we'll just see.
Yes.
So if we find that it is there, then your
Lordship, you can take it. Yes.
Yes.
We have difficulty in placing the record of this case, this matter.
No, man.
Then we place it. We'll just verify. If that be the thing, we'll finish it. Why to go all those things?
No, my lord, can you come to page 133?
Is there any statement in a writ petition that this is the factually not correct? What has been written?
Before my lord, he answered to that, I would just like to take my lord to page 133 and it's 15.
Yes.
My lord, can you see before the EM in charge Land and Revenue Guarantee from this council case number so and so, the issue suggested by the opposite party, Srimati so and so, it is he who has suggested these issues, my lord. And if the issues was not framed, then why this petition was filed? My friend has a very good case, my lord, but he is not going to that point.
What is your statement in the writ petition that this has been wrongly this thing? This, what has been reflected in page 151 is not correct. Then only we call for records. Otherwise, we will not call for record. Why should we call? Why should we disbelieve this order?
There's the repetition 147, page 147. It's the order dated 26/8/2016.
Page 1.
147.
Just a minute. One?
147.
This is the order of the High Court, my lord. The last order of the High Court.
No, your petition. You show us, you said that though it is reflected in the order that issues were framed, witnesses were examined, but then these are not factually correct. Isn't it?
Yes.
So there must be a statement to that effect in the writ petition. Please show us where it is.
No statement.
No, it will be there, Lordship, because
No,
because
then
I have,
this will cast a stigma on that officer who passes the order. This is a very serious thing. Because he has recorded something, and the contention of the learned counsel is that there is nothing as such. So if this be the thing, we cannot casually take that thing, because this is the main thrust of his case. You just show us where is that statement.
yes, Lordship,
If this be the thing, we can dispose it by the small thing also, because this is his sole contention, and if they cannot substantiate it, then matter goes. We do not have to enter into merits and the factual aspects of the thing.
Now, if we have to strictly follow the order of the Honorable High Court, my lord, whatever is the contention of my learned friend, that also we don't need to follow, my lord. Because the High Court has said us, give opportunity to hear them and decide as per the record.
No, that is all right, but then it doesn't mean that you should not follow other requirement.
No, we are bound to follow, my lord.
Once
If that is the contention, only contention, then we don't need to follow, my lord. Because it was given, an option was given to the.
No, Mr. Day, see, if High Court remands the matter by saying that opportunity has to be given to him, but then that giving that opportunity means that framing of issues also. But then once it is reflected in the order that issues were framed, and then witnesses were examined, and you have pointed out even they have submitted their suggested issues. Thereafter, it becomes basically their duty to show at least to make a statement that it was not in fact done. So let him show it. If he fails to do that, then we will say that there is no basis of filing this petition. Another aspect concerns merit, we will not go into it.
Lordship, because I have so many statements, it will require for me to go through because to assist it, because this is very after 2 weeks loss, because I will go through and I will say because it is not that I'm avoiding the case, but when the query is given to me, I cannot simply say anything whatever is there. So I have to give a better assistance and to satisfy this court.
Before
Lordship.
you come, you know your case, and before you raise some specific contention, please come prepared.
Yes,
How do you support those? It should not be something like you make a statement in the air. You see, when you say that there are no issues were framed, nothing was done, no evidence was collected, this court was interested. And definitely, you see, they have the duty, but then doesn't mean that they will discharge duty the way they want. That is, isn't it?
Lordship.
At least the principle of natural justice, the minimum standard of a proceeding has to be followed.
Lordship.
Now, you say something, but then there's no support in
Will
it.
be there, Lordship.
Even
Yes,
the
yes,
materials on record doesn't support. Mr. Day has pointed out.
Lordship, then at that time, let the record also make order at the
No, you
meantime.
first show us where the statement, then we call for it. You have the record with
I
you.
think
Mr.
earlier
Day.
the court has called for the record.
Then it's better if you.
No, that I will do it, my lord. Let him first make a statement.
No, earlier there is order, Lordship, for calling for the record. There is order from this
Where
court.
is
Yes.
that order?
Lordship, I exactly forget, but that date of that. But there was. I will
If
find
there
out.
is order, then this court
Yes.
doesn't have to pass any more orders.
Yes, it is there.
Okay, we'll see. But just
The EM order is there.
It was asked to produce the EM order, sir.
No, CEM.
CM.
anyway, whatever the thing he wants some time because he says there are so many voluminous statements.
Yes.
You'll have to go through it.
Yes, Lordship.
But if your Lordship
But
wants,
then by adjournment, taking
No,
adjournment, how
no,
long you
Lordship,
will stay?
Lordship, my humble submission, Lordship, because this is, Lordship is very much aware, this is a very serious case, because I cannot simply, all the cases are serious, all the cases are, that's why equal opportunity should be given, not just because, just,
You want to say
no,
that
no,
this
no,
court
I'm
is
not
not
saying
giving
that, Lord,
opportunity?
I'm not saying that the court is not giving an opportunity, but I'm saying that ample time also must be given, because since when the court is asking the question, I should give,
No, this is a case of 2018.
yes.
You do not have ample
6 years has
opportunity
gone.
till now.
The
6 years is not
Lordship,
enough for
it is
you.
not because of the petitioner, but because the earlier my senior colleague or the senior advocate also admit there was a changing of lawyers so many times. He is the latest one. Prior to that, there are other 2-3 council.
He
They are
has
appointed.
not asked for time.
Then after that, this year only I think they were
Mohanto,
engaged.
with his long experience, knows where to strike, and that is why he showed your prayer initially.
no, now also I want to come back to the prayer, your Lordship.
You will not go here there.
Yes,
you will
yes,
just only strike.
Yes,
the
that
point which is needed.
yes, that's why I need time to reply to the senior advocate in the court, Lordship. I just ask time kindly because yes,
Lordship,
yes, because this is not an urgent case also.
We have that video recording and we are lucky. Otherwise, my friend may have made a statement somewhere else that opportunity was not given to him.
No,
The
I'm not
same
saying.
thing is doing here.
I'm not saying, but I'm saying that
He did not mean that.
I'm yes. Sometimes what we say, I don't know. Maybe speaking is different. Maybe understanding also different because my intention. But actually, my lordship has found out. Actually, I don't mean it. But sometimes, as I have said it earlier, sometimes it is due to inability to express. That's why there's some communication.
Can I just
Because
have
that's
this honorable
You
court?
come prepared.
Yes,
You see,
Lordship,
there will be
Lordship.
see, we can understand that. See, we have communication back. There is
yes, Lordship.
Sometimes we are not able to express whatever is. So this language problem even this court also has.
Lordship, let me honestly submit to help my colleague. I think I have just saw a paragraph here. If Lordship permits, paragraph 27. 27. No other places, only there, here there is a small sentence. Your Lordship will see if I'm permitted to read. Page 26. Page 26. So I'm helping this.
Yes.
Sangma, that the arbitrary act and non-compliance with the due process of law and judicial procedure in disposal of the so-and-so 2000 White order dated 2/6/2015, GS appeal number so-and-so 2015, judgment and order dated 14/6/2017, 16 I mean, then White order dated 28/12/2017 and JSC revenue appeal interest 8/2018, White order dated 12/10/2018, the response so-and-so, Garo Hills Hotel District Council, and the response so-and-so, Hills Hotel District, without taking into consider plea and the issues raised by the petitioner, amount to violation of the principle of natural justice, your Lordship. Since the subject matter can be solely decided on the basis of the records available with the petitioner's district council. Only this sentence is there.
But then doesn't specifically deal with
No.
this thing. It doesn't say
No,
so.
no.
That is his contention that,
That
which
is his
issues
contention.
which he has raised,
So,
court has not given.
apart from that, there is nothing. What Lordship's query, apart from this, there is
No,
nothing.
that is what.
So I don't think that any more time can be given, your Lordship.
No.
No, my respectful submission, I'm helping you.
No, there are many other things as Lordship. Because when I asked them, because he is not, the Lordship was already in the,
So,
on the
for
next
this, I
day.
think
Let us give him one more
Yes,
opportunity.
yes,
with
yes,
this.
Lordship, yes, Lordship. Yes,
Now
Lordship.
you are there, you will remember it, you can point out from the next day. And if he fails, Mr. Sangma, one thing is that in this kind of petition, if you argue on merit, especially in a 226 application, this court cannot help you.
Lordship.
You know the power of judicial review, the scope of judicial review is very confined. It is only the decision-making process, not the merit of the case. Okay, or if you can show something perverse. Otherwise, very difficult. You see, hard. Mr. P.T. Sangma, learned counsel for the petitioner, and also Mr. S.P. Mohanto, assisted by Mr. L.M. Sangma. Oh, you are be appearing for
District Council.
restaurant number?
1 to 3.
Oh, then
1 to
before you write, Mr. Mohanto, Mr. S.
I'm for 4.
S. Day for restaurant number 1 to so and so, and Mr. S.P. Mohanto along with Mr. L.M. Sangma, learning counsel appearing for private restaurant number so and so. Mr. Sangma, in the course of hearing, in the course of the hearing, the learned counsel for the petitioner prayed for grant of some more time. Prayed for grant of some time for further preparation in the matter.
Lordship.
You say you have no objection.
Lordship, I think
Anyway,
can we after
learned
week,
senior
after
counsel,
a week's time? I think.
learned senior
No,
counsel
2 weeks
has-
will be too long because why?
learned
Under
senior
matter is
counsel
also
has
pending.
objected to the prayer made. However, in the interest of justice, 2 weeks time is granted
Lordship.
to the petitioner,
Lordship.
to the learned counsel of the petitioner. Stop, list accordingly.
Much.
Finish.
What's the last, Lordship?